Well, good evening, everyone. Good to see you here tonight. For those of you that don't know me, I'm Chuck Gotti, the Geary County Ag and Natural Resources Extension Agent. This kind of started off serendipitously and just kind of exploded and grew on us. And as you can see, we had over 80 people registered here. We've got about 400 people that registered for online. So you didn't come to hear me, so I'm going to get it handed over to the speaker here. Our speaker tonight is Roger McEowen. Roger is a professor of agricultural law and taxation at Washburn University. He is also with the KSU Ag Econ Department, which is a valuable asset to all of us county extension agents. When we have questions like this, and every extension agent has questions on this very topic, we immediately turn to Roger. So without any further ado, Roger.
Thank you. And thank you, Chuck. And stay here a second. I think they probably all know that in 9 days you walk away. Is that right? After how many years?
40 and a half.
40 and a half years. Isn't that something? Great. I know when I first came to K-State, I've had two separate stints. When I first came to K-State, you had already been here a number of years.
Yeah.
And you've been in the same county the whole years. And I remember when I first started, my boss, which was Barry Flinchbaugh, said, I'm going to send you, in his voice, I'm going to send you around the state. You got to go spend a day with county agents. And I thought, no, I don't want to travel the four corners of the state and spend a day. But I'll tell you, that was the most valuable thing that I could have done, was spend a day with a county agent. I don't think you were on the list because I was in the four corners. And so you're kind of inland a little bit. But that was very valuable for me to see what you guys do on a daily basis. And it's greatly appreciated. So job well done. Good to be here for you. Okay, before I get going, the gentleman standing over here is one of our associate deans at the law school, Sean Leisinger. He's the associate dean for external programs. He also runs the rural law program. And I wanted him to say a few things to you so you can get a feel for what we do at the law school for our rural law students, and a third-year anywhere program and a summer externship program for rural law firms that we have, so that you know that we're kind of unique from the law school further east of us. I can't remember what they're called, but we do offer students opportunities in agricultural type legal issues and getting them trained on those issues, and hopefully restocking some of these rural areas out in the Plains states and across the country. I have a student, former student that just started this last week with a firm in Havre, Montana. That's about as remote as you can get, but we're getting them out there. So Sean, if you could take a few minutes and tell people what we have to offer for our students.
I'll do just that.
You'll need both. This is for the online crowd, the big crowd.
Yeah, we'll just do it. All right, I'll try not to talk in double speak, I guess, here, since I've got to talk to two different microphones. As Roger noted, my name is Sean Leisinger. I oversee a number of different things at the law school. One of the things I oversee that I'm most proud of is our rural law program. And I'll talk about that for just a few minutes here and give you an idea what it is. And I'll explain to you why it might matter to you as well. First, give you a little bit of bona fides for me. Roger and I we're chatted back and forth a little bit. He'll be talking to you about fence law tonight. When I started, I'm a Washburn law grad many, many decades ago. Early on, I got to do a fence law case. And I worked for county commissioners, and my third county commissioner was a former beauty pageant winner who took very good care of herself. And I loaded her up in my four-wheel drive truck. We hopped out across the fields, way down to a fence that a couple neighboring property owners had been arguing about. She was dressed to the nines, had a beautiful pair of heels on. I had to advise her as she got out of the truck to watch for the little surprises the cows had left. We finished, we did the fence view, went back, and the county commissioners did all the formal sort of stuff. But back then, when I had to kind of figure out for myself how to do that as a Washburn lawyer, I dutifully did a little research. And the article on fence law at the time was written by this ag law guy called Sam Brownback. It was an 8-page article, and that was at the time kind of the Bible on fence law. And Roger may touch on that a little bit later. Roger and Sam actually after that updated and improved and everything else. So there's a little bit of my bona fides and ag law and everything else. Our program is really focused on trying to do a couple different things, trying to replace the lawyers in rural Kansas that when I speak, I say that they're aging out of service. They're dying, folks. They're literally in their 70s, approaching their 80s. They've served these communities forever, and they'd love to retire, but they're the last attorney in the county, the last couple attorneys in the county. So we're trying to get law students to want to go back out into rural communities across Kansas, and we put together a number of different programs to do that. We are the first law school in the U.S. to have a third year anywhere program. So our law students in their third year of law school can go out into that community. They work with a lawyer. They get extra credit for doing that. They actually get to learn hands-on what it is to be a rural lawyer in a small community, to give back to the community and actually serve the folks that are in those particular areas. We have a rural law summer program. A number of my students are in Northwest Kansas. They go out into communities in that area under a Hanson grant and get immersed that first summer in all the things it is to be a rural lawyer. These are things that we're doing at Washburn to basically try to replace those folks. Quite honestly, the Kansas Supreme Court has now realized they're having a shortage of judges as well in these areas. And all of the young lawyers that would come out, serve in the community, end up getting elected county attorney for a while, end up kind of replacing the judges as they retired. We're trying to get that pipeline started again. Why that matters to you, if you have folks that are in your communities, if you have people that are interested in going to law school, send them our way. We are probably one of the preeminent law schools in the US, reaching out to those folks and trying to address this particular problem. But we need to get that pipeline kind of started and get folks to come to the law school and go back out into those communities. That said, if you have folks that are interested in ag business and more of kind of the business sort of side, a law degree is a great thing for them as well. So if you have questions, if you're interested, if you have family, friends, whatever in your communities as you go back out there, both for those of you that are online and those in present tonight, please feel free to send them my way. Just Google rural law at Washburn or go to the website, Walter, that Roger will tell you about, and we would be happy to try to reach out to those folks on your behalf. Thank you for giving me a few minutes to talk. I'll pass it back over to Roger.
Okay, thank you, Sean. Appreciate that. And K-State also has an ag mediation service. Many of you are probably familiar with that. Kay and Crystal are in the back of the room. They have a table set up there, and I think they put a little brochure on each of the seats. Of course, nobody's picking them up in the front row because you don't sit in the front row. I caught some people a number of years ago at an event. Well, when we broke for lunch, people had left their workbooks. This was at one of the K-State tax schools along the back row. And I told the hotel staff, I said, here's what I want you to do while we're out into a different room for lunch, set up another row behind those books. And so we set up another row. Their books now were in the second row from the back. And it was fun to watch them when I went back up to the podium wondering, you know, are those my books? I thought I sat on the back row. It took them about a half hour to figure out. Those were, nobody touched their books. Nobody moved their books. We just put an extra of tables and chairs up in the back. So, you know, there's some joy you can get by being ornery now and then. But no, I would reiterate the law school. I don't know if any of you've seen it or not. The law school is putting up a new building in Topeka. I think I've actually driven past it maybe once. Because I'm on the road all the time and I'm not there that often. I did suggest to our new interim dean that it should be chiseled on the front of the law school, Washburn Rural Law School. Now there is a high school in town. Well, that would be appropriate. He looked at me and he said, I can't sell that to the faculty. I said, well, I think it would be appropriate. That'd be pretty cool. One other thing, and let me put up contact information. It is also on your handout for you. Hopefully everybody picked up a handout when you came in, or at least each family represented picked up a handout. That's my email address as well as the website address. And if you're into Twitter, I don't know if this crowd is a Twitter crowd or not. Feel free to follow me on Twitter. How many of you have heard my daily 2-minute show, the Agricultural Law and okay? And you'll probably recognize the music on the front end and the back end of that. Those of you that heard it, you know where the music comes from? That's John Mellencamp. That's from Small Town. I'll just put a plug in here. This is just something so you know. John Mellencamp, I wanted that sound because he's one of the founders of Farm Aid. He has cousins that farm in Indiana. My family farms in Indiana. That's where I'm from, opposite ends of the state. But that has a message that I'm trying to convey, and I try to convey that to our students too, that you don't have to go off to a big metropolitan area to be successful. You can be yourself in a small town. And that's what he's singing about there. And so I wanted that sound, but I had to figure out a way to get license approval from him for that. Long story short, there was a farmer in Kansas that hooked me up to someone that hooked me to John's manager that got me to John. And John had never let anybody touch that sound in 37 years since he wrote that. And it was released. No Hollywood movie, no corporation. And when I got it to him and he could hear it, he's allowed me to use it gratis because it's agriculture. Isn't that something? And it was, he no longer owns the rights to the music, but, and so I had to be sent to Sony Music Publishing Company, and the president of Global Marketing Relations called me when we were getting down to the nitty gritty on licensing. And he said, I couldn't believe the request that came through. And it was to a gratis license for this agricultural law and tax report by somebody out of Kansas. So he said, I called him. And he said, I'll tell you, I just got off the phone with John. And John said, Brian, let him have it. It's ag. So I thought you might like that little piece of information that's out there because it's agriculture. He liked to be associated with that. So with that, let's talk about fences. And this is, by the way, what Sean was talking about. These are courses at the law school that our students can take that touch in one way or another on agriculture. Agriculture, of course, the legal system, good, bad, or whatever, is tied pretty heavily into ag production, rural land ownership, which we'll talk about this evening, in fence law, but estate planning and tax. I travel the country teaching farm tax and estate planning to CPAs and lawyers all over the place. Just came back in from Grand Forks, North Dakota. I'm in Montana next week, was in Colorado and the state of Washington the last couple of weeks. So constantly doing that, but we have courses that they can take. Now, they can't all take this. They're not going to be able to take all of these courses, but they can pick and choose and get these courses over the course of their 3-year stint at the law school. And so those are courses that have something to do with agriculture. And we just can't take a law student and park them out into a rural area and not have them trained in legal issues, because agricultural law in many instances is law by the exception. Congress has created special rules for those that are engaged in agricultural production. So they have to be specifically trained if they're going to be competent to represent you in the legal issues that you face. In Colorado, a couple of weeks ago, or about 3 weeks ago, I learned that water in Colorado and out west flows uphill toward money. And fences create problems. So we're going to talk about the rules that govern fence law this evening, and boy, does water flow uphill toward money in the western part of the US. But our primary issues when we talk about fence law is, what is a partition fence? So what is a partition? And that's going to be where I start at in the discussion. And I'll generally follow your materials, the 9-page handout that you have, which can be found on my website, the Walter website, washburnlaw.edu/Walter without the E, WALTR. And then construction and maintenance issues Okay? That'll bring in issues with respect to county commissioners, and I'm sure some of you here are county commissioners or have been, or perhaps for whatever reason aspire to be a county commissioner. When I first started out my legal career in Nebraska, in the Sandhills in Nebraska, I defaulted into a county attorney position, which is a long story. My wife and I'll give you the short version of it. My wife and I bought a home in the county north of Lincoln County, where North Platte is at. We were in the next county north. So the one town in the county, the one incorporated town, was where we bought a house. About 300 people, actually 299. And when we moved in, they were so pleased that they went out and spray painted the 299 and wrote 302 on it. So they were so happy at that. But then I learned later on that Nebraska had a statute that if there is no resident, well, if there happens to be the county attorney who's not living in the county, and then I moved in, I become automatically the county attorney. And of course, when I went to law school, I avoided all of the trial courses, the criminal trial stuff, all of that. I'm not going to do that. Tax, estate planning, real estate, farmers and ranchers issues, and here I am, county attorney. There was also another statute at the time that said if there was no resident medical doctor, the resident attorney got to be coroner. So I have a very strange background. Two things I have absolutely no understanding of. And I remember the first time the judge came around, he was one that wrote a circuit, and he would have 6 to 8 of those Sandhill counties. And he looked at me the first time and he said, "You're new," because he'd been dealing with a county attorney that had been there for 38 years that got displaced overnight by a rookie by default. And he said, "What's your background?" I said, "In this? Absolutely nothing." He said, "Well, I tell you what, when we have a case," and fortunately in the county there weren't too many problems. Just one family gave us the whole problems. We just went right down the family line. The oldest son, the next one, the next one, the next one. That was it. And he said, "I will frame questions so that every answer is a yes. So you just answer yes, and we will dispatch of all of these cases." So that's how those things were done in the Sandhills in Nebraska. And I remember telling the county commissioners, for those of you who are county commissioners, I said, if we ever have a felony in this county, I can't deal with it for 2 reasons. 1, I don't know how, and 2, I have no budget. So that's where, if we ever had something like that, the idea was it was just going to kind of disappear quietly in the vast expanse of the Sandhills and never be heard from again. That's what would happen. Fortunately, I got out of that within 2 years. And when I got a call one evening from this guy at K-State that had that gravelly voice and said that, "I'd like you to come here to replace our adjunct that wants to run for Congress." And I hung up the phone. I remember hanging up the phone and telling my wife, "I just got a call from a guy that's got the funniest voice in the whole world." But anyway, that was my first stint at K-State. So that's what I did. That's where I ended up. And Chuck and Sean gave you a little bit more of the background on that. But partition, construction, maintenance, what happens if animals get out? Who's responsible for that? And that's a fence issue. The fence viewers, who are they? And of course, that's the county commissioners or a couple of them by designation. And then how do we handle stray animals, issues associated with stray animals? So let's dig into this. Let's start with partition fence. What is a partition fence? Because the fence statute is keyed off of the definition of a partition fence. That's a fence that's placed on the line between tracts of land that are owned by different persons. And so that is the partition that is separating the properties. Now, it can be located, a partition fence is not necessarily on the surveyed boundary. And this is where we get a lot of the legal issues. And a partition can be located on one side or other of the actual legal boundary to the properties, but it can, if that's the case, if it's not actually on the legal boundary and it's off of that, usage of that as the boundary for a period of time, which is 15 years in Kansas, can lead to that fence line becoming the actual boundary under a couple of theories. And this is where we get a lot of the disputes, a lot of the cases on boundary disputes because of this usage over a period of time. And indeed, in agriculture, And this is something that's not well known by people that don't live in the country, particularly if you get somebody in town that buys a 40 or buys a 20 and they are out in the country and now they're bordering you. They think that survey is golden. Well, not so much. In agriculture, usage of property may actually determine a boundary more often than does a survey. And a lot of non-ag people don't realize that, but that is true. You know, it's usage. And so we always have to check what the usage was and what's actually been filed down at the courthouse. Is there a written fence agreement that's been filed? And a lot of times people don't check. Now, the theories under which that, we'll call it a misplaced fence, can become the actual legal boundary of the property. There are two of those. One of those is adverse possession. So as I work down through this is toward the bottom of page 1 in your handout. Landowner can acquire title. This is the dry, technical, legal definition of this, to property by making an open and notorious use of the property for 15 years. That means you're not trying to hide the fact that you are asserting ownership over this disputed area. You know it doesn't belong to you, yet you're continuing to farm it, you're continuing to graze it, you're continuing to use it. That's open and notorious. That's known as a hostile use, although hostile is not in the statute, but that's a term that is commonly used. Do that for 15 years, then you can file a quiet title action in court and have that disputed area, have the title to that quieted in your name. So that applies, adverse possession applies when adjacent parties know that the existing fence is not on the boundary and one party is benefited by the misplaced fence and is the misplacement of the fence benefits them. So if they use that disputed area, they're gaining land adversely to the other party. The other party knows what they're doing. They know the fence is not in the right place, but then they don't do anything to stop the other party from that possession. And if they sit on their rights for a long enough period of time, 15 years, then they can lose that. Now that's a concept that is a carryover from England. Centuries ago, actually from about the 11th century forward. It was originally known, a variant of this was known as squatters' rights. And this is the modern day variant of what that theory was. Now, the elements to adversely possess a property in Kansas, you have to, this is the statute, openly, exclusively, and continuously be in possession of the real property that is knowingly adverse to the true property owner. Okay, so you got the elements there. It's out in the open. You're not trying to hide the fact that your usage of it is contrary to the correct ownership. It's exclusive. Nobody else is doing this, just you. And you do it continuously. There's no breakage in that 15 years. If there is a break, then we're going to start the 15-year period over again. So it's continuous. So I farmed it up to a particular line that I know is actually over the true property line. And the true owner knows I was doing that and didn't stop me from doing it. That's what adverse possession is. Now, at the top of the next page, related to this, and sometimes courts confuse this, adverse possession is one theory. Practical location, the doctrine of practical location is very similar, but it's a little bit different. It gets to the same result, but this is the situation where neither party really knows where the boundary is at. And we just kind of farm up to a particular line, or, we've got a fence there, but we don't really, we know that's not the boundary, but we don't know where the boundary is. So this doctrine applies when the parties know the existing fence is not on the boundary, but they don't know where the boundary is located. Again, after 15 years of usage of that particular line or of that particular fence, that can cause that to become the actual boundary to the property. So you get to the same result. One is where adverse possession is where the parties know where the line is at, and one party is allowed to adversely possess it, and somebody else, the other owner, just kind of sits back. Oh, I don't want to rock the boat. I don't want to say anything. I don't want to create a fuss. Well, you sit back long enough, you could actually lose that. Doctrine of practical location is where we don't know where the boundary is at, and I'll just treat this as the boundary. The other party treats that as the boundary. And after 15 years, one of those parties, whoever might be benefited by the uncertainty, could file a quiet title action in the local county district court. Okay. All right. So you get the same result, two different ways to get there. Now, with respect to partition fences, we have what building or maintaining these fences, the equal share rule. That's statutory. It's not halves, but it's an equal share of the total cost of building or maintaining a fence. The statute says, so long as the parties, the equal share rule applies, so long as the parties continue to occupy or improve such lands unless otherwise agreed to. So what that's saying is that I could agree with my neighbor as to how we want to build and maintain a fence. We could record that in the land records, and that removes us from the equal share rule. I might say, well, I don't want to spend my time to fix the fence. Here's the agreement we're going to come up with. I'll pay X, you fix it. Yeah, you can do whatever you want. Very few people execute a written fence agreement. Does anybody here have a written fence agreement with your neighbor? No, that's why you're here. You want to figure out if you can sue your neighbor. If I had one of those, I wouldn't be here. Okay. But you can modify that by agreement. You can enter the neighboring land also at reasonable times and in reasonable manner to maintain the fence. That's not a trespass. You can cross over onto your neighbor. They can't sue you for trespass if you're doing so in a reasonable manner and at reasonable times to fix the fence. Now, reasonability is a fact-based determination. We get a lot of cases over the years, and fence law cases go back to statehood, but there are a lot of cases out there on, well, what's reasonable? Okay, it depends. It depends on the situation. Can I cross the line and cut down my neighbor's trees? Probably not. That gets, was that necessary to build and maintain the fence? Sometimes it is. Sometimes it's not. It depends. The reality in practicality, what people do is adopt either the right hand or the left hand rule. And that's probably what many of you do. You just meet your neighbor midpoint of the fence. We look at each other. I fix what's on my right. He or she fixes on what's their right. And that's just the agreement that we have. Now that's pretty common, but that's not statute. That's not what the statute says. Statute says equal sharing of the total cost of building and maintaining a fence. That could require one adjacent landowner to build 3/4 of the fence and the other one 1/4, because that 1/4 is going through water and trees and all kinds of rocks and hills, and the other one's just flat, level, soil. So that's why the statute says equal shares. Is there a written fence agreement? If so, you can record it, and that will bind the current and subsequent landowners, because the fence agreement runs with the title to the real estate, so subsequent owners are subject to a written fence agreement. I have seen very few of those, probably about 5 or 6 over the last 30 years, the people that actually had a written fence agreement. And you can get into pretty abusive situations if you have a clever adjacent landowner, or if you want to learn a trick tonight, you can pull this on your neighbor. This is an actual case that went through the Iowa Supreme Court back in the 1960s. There was a father and son. They were attorneys. They bought some Iowa farmland. There was no written fence agreement with the neighbor, and the fence was in bad shape. The partition fence was in bad shape. And so the attorney family went to the other adjacent landowner and said, we've got a pretty beat up fence between us. Why don't we adopt the right hand rule? You fix what's on your right, I'll fix what's on my right. The other farmer thought, that's a good idea. We do need to fix this fence. So the farmer very dutifully right away goes out and fixes his part of the fence. And this was like a ½ mile long. And so he fixes a 1/4 mile of fence. The attorneys didn't do anything right away, but a week or two later, the farmer's sitting at home reading the local newspaper, and he's reading the real estate transactions in the newspaper. He notices this conveyance of land, and he thinks the legal description looks, that's pretty similar to what I've got. Well, it described a tract of land just on the other side of the fence where the attorneys lived, and it was a 1/4 mile long and 25 feet wide. What the father did was he conveyed it to his son. And now the son went back to the farmer and said, we've got a 1/4 mile length of fence that's in bad shape. Why don't we adopt the right hand rule? You fix what's on your right, I'll fix what's on my right. So the farmer thought, I just fixed it. Oh, I get it. He's the new owner. I got to go fix that. So he fixes, what would that be? 1/8 of a mile of fence. And about 2 weeks later, he notices another transaction in the real estate records. I'm not making this up. This is an actual case. That son conveyed the land to his son, so a grandson, and it was 1/8 of a mile long and 25 feet wide. A couple of weeks later, knock on the door. I'm the new landowner on this 1/8 of a mile, and there's a bad fence between us. Why don't we adopt the right-hand rule? You fix what's on your right, I'll fix what's on my right. See what the attorneys are doing, they're getting the fence fixed free of charge using the right-hand rule. Well, the farmer was pretty swift. He pulled out a Colt 45 and shot the grandson dead right there. No, that's not true. He filed a lawsuit is what happened. And he lost because those transactions were legal. Those were real estate transactions. It was a new owner. They were following the law, but they were just manipulating it to their benefit. So you can get around that kind of monkey business with a written fence agreement. Very few people do that. Okay. Online questions. Okay.
So one of the questions is, how do you establish the age of the fence? Going back to if you farmed it for 15 years, how do you know it's been 15 years of the age of that fence?
Okay, how do you establish the 15 years? The question was age of fence, but it's, how do you establish usage of 15 years? That brings up another point that I passed on, but it's a good point, is can I tack a previous owner's usage onto my usage to get to 15? So let's say that the previous owner had used it in the same way with the adjacent owner for 10 years. Now they sell to me. Can I count their 10 and I only need 5 to get to the 15, or does it start over? You can tack on a previous owner's usage if there's no change in the actual usage. That usage has to be the same. So the court's going to make you prove that you didn't change anything once you acquired that property so that you can tack on the previous owner's usage. It is, to the nut of the question, it is a proof issue. You have to have proof of what the prior usage was, what your usage is. It has to be the same all the way through to be able to tack. Okay. And I get that tacking question quite a bit. Yes, it's possible. It can be hard if you don't have good evidence. Okay.
All right. And
Another
then,
one?
yeah, the next one, so you built the fence knowingly inside the property line. So the farmer wouldn't hit it with their equipment, we'll
Yep.
say. How do you keep the other person from adversely possessing that land, knowing the fence is inside the property line?
Okay, for those who might not have heard her, I don't know if you can hear in the back. What if I build it inside the line so that the adjacent owner's farm equipment doesn't damage the fence on the partition, but it's inside on me a few feet? How do I prevent that gap then from being adversely possessed by the other party? That's where you want, if you do that, you are at risk by getting to the 15-year statute. And keep in mind, not every state, and I know we've got people from about 12 different states online, not every state's statute is 15 years. There are some that are 5. And so 5 does not take long to get to. Some are over 20 years. It's just all over the board. Nebraska is 10. So some states are can be shorter than 15, but Kansas is 15. Now, what you want to do in that situation is you want to have a written agreement. You want to have a written fence agreement. You want to record it on the land records as to what you are doing. That I'm putting the fence inside the actual boundary. The actual boundary is this designated line. Give the legal description of it, and we are not changing that, so that that's on the land records. That'll prevent that 15-year statute from running, so that you won't lose that strip. Okay? But again, very few people do that. Yes, back here. No, I think the example was I built the fence inside. It needs to be on both. It needs to be on recorded. Yeah, that agreement needs to show up on the deeds for the adjacent properties. Okay. So it'll bind both landowners and subsequent owners of those tracts. I think there was another hand back here.
So you're saying
Yeah, it needs to be filed in the deeds and recorded at the Register of Deeds office. Okay. I think the online question now just opened up the live audience here to the in-person audience to asking questions.
Yeah, follow up on that. What if the adjacent landowner won't enter into a written fence agreement?
Okay, if the adjacent landowner won't do it, then you have to do it by basically a memorandum that you can record and have an affidavit associated with your deed. It's not as good, but nevertheless, it is a document we can file.
Better let you keep going because the questions are just pouring in.
I anticipated as much, yes. Yeah, I did, when I first started the 2-minute daily radio program, and now it's on 193 stations nationwide plus Sirius XM. And early on, I did a 3-part series on fence law. Oh my goodness. I told my wife, I'm just gonna have to hire somebody to monitor my email. I got pictures last week from a landowner in California out near Fresno. He writes me this letter, sends me pictures of his family and his dog and his farm. And he said, I wake up every morning, you come on at 5:30 on the Fresno station, just love it, it's great. But now this is multiplying itself all over the place. So I get these pictures and so forth, which is great. But I tell you, I do something on fence law and this is what happens. I get all these questions. One of the questions came in was from Vermont. It was a fence law question. I don't know fence law in Vermont. So I kicked that to my research assistant, said, you guys figure this out and tell me what the answer is. So then I look good when I answer the question. That's why we have law students, right? Yeah. Okay. All right. Fence law theories. Let's get into this a little bit. This is toward the bottom of the second page. And we have 2 approaches, nationwide, fence in, fence out. And many of the Western jurisdictions west of Kansas are fence out jurisdictions. Under that theory, if you've got livestock, the non-livestock owners are supposed to put up a fence to keep your livestock out. That's not what Kansas is. Kansas is a fence in jurisdiction. That's the common law approach across the country. So if I fail to keep my livestock on my property, that subjects me to potential liability. Okay. So we are a fence in jurisdiction. So if I have animals, I have to put up a fence to keep them in. Okay. But there's a limitation. Well, we come back to the equal share rule. How does that work when the livestock owner in a fence in state is supposed to fence their livestock in, but yet we have an equal share statute that says the parties are equally responsible to build and maintain a fence. Now, those seem to be at counter purposes there. Well, we have a statute that the legislature tried to clarify this, and they did it in a confusing way that this really confuses a lot of people. It confuses county commissioners. I have to sort this out more than any other aspect of the fence statute to get more questions on this aspect of it. One of the things you want to going into this is that this part of the statute is very favorable to livestock owners. That's the way the statute was written. And what we get into is a situation where you've got a livestock owner on one side, so you got pasture on one side, and you got crop ground on the other side. Well, the crop farmer doesn't need the fence because the crops don't have a tendency to get up and walk away in the middle of the night. So he doesn't want a fence, doesn't want to pay for a fence. And they'll say, well, this is a fence in state. You got the critters, you fence them in. So how do you resolve this? Well, here's what the geniuses in Topeka did a number of years ago. They said, well, yeah, a crop farmer doesn't want to share equally in the cost of building and maintaining a fence when they don't need a fence. Well, they said one thing, okay, we got this equal share rule. All right, crop farmer, if you don't want a fence, and if you don't participate in providing your equal share for building and maintaining the fence, then if those livestock escape and damage your crops, you can't recover. Okay, that's one way to kind of incentivize the crop farmer to pay for part of that fence. All right, if those animals get out and you didn't pay for any of the fence and they eat your crops or trample your crops, you're not getting anything. That's one way they did that. And they also said, as another subpart of the same statute, if you didn't participate in building or maintaining that fence and your neighbor's animals get out and they go across your property onto somebody else and damage somebody else's property, you're also responsible for that. Oh. But then the legislature didn't stop with that. They didn't think that was enough. So on this issue of being forced to build and pay for an equal share of a partition fence, they said, well, okay, crop farmer, you can't be forced to do that if the adjoining tracts are used in common. And that's the language they used. What in the world does used in common mean? What it means is if there's crops on both sides. If there's crops on both sides and your neighbor says, I want a fence, I'm going to make you pay for half of it, you can say, no, because livestock aren't involved. That doesn't invoke the fence in theory. So if it's crops and crops, that means it's used in common. Common means use the same usage on both sides. Now, if it's livestock and livestock, it doesn't matter because both parties need the fence. So the situation here would be crops and crops. One party can't force the other one to pay for a partition fence. You want a fence? Put it up. Okay, that's your problem. All right, now there are two requirements for that to apply. One party doesn't want a partition fence and the adjoining tracts are used to grow crops. So if you have that situation, then one of the crop farmers that doesn't want the fence cannot be required to pay for the fence. So the statute only applies to relieve a landowner from the responsibility of sharing equally the cost of building and maintaining a fence on a partition. Again, I'm always talking about partition fences here. When the land is used in common and the complaining party does not want the fence. Again, just for the online audience, if you're not in Kansas, these are the Kansas rules. Every state's rules are different on this, but these are the Kansas rules. What if the parties can't agree on fence building or maintenance? So we've got, let's say we have an issue where we want to build a fence, but we can't figure out how to allocate the cost of building the fence, or we've got a fence that needs to be rebuilt, but we can't come to an agreement as to how to rebuild the fence. Well, of course, the first step is try to resolve the matter privately. If that doesn't work, then you call the fence viewers. Okay, those are the county commissioners in Kansas or their designees in the county where the fence is located. Then you get this unique issue, actually two, I didn't put the other one on the screen. What if the fence is on the county line? No. Okay, then we got another subsection of the statute there. The statute says the chairman of each county board or commissioners, if you can't agree, those will be the fence viewers. And if there's still no agreement, then a third viewer is selected from the county fence viewers in the county. So they can pick a third person from either of the counties on the commission boards to be that third person to break a tie if the two chairmen can't agree. But that's for the fences that are on the county border. That decision then that they reach has to be recorded in the land records of each county at issue. Now, the other issue I didn't put up here is what if I border land adjacent to an Indian reservation? Anybody got that issue? Yeah, they're not subject to these statutes at all. They can just blow you off and they're not responsible. It's your problem. Okay. That's a whole different issue when you get into tribal stuff. Yes. Well, we don't have too much of that. We have some. The question is, what if it's federal land that I'm adjacent to? Then you have to deal with the federal government on that. And that's a good question. I think just off the top of my head, if I recall that correctly, I don't recall. I'm going to have to I think I know the answer, but I want to hesitate to state because I think I may not be correct. If you want to email me on that, you got my email address. I can. It's state land. The state's subject to state statute. Okay. I do have a case in here, the Chesbro case on this one, on that issue. Okay. Yes, over here.
If that state or county or city property that's on the other side of the.
Yeah, that was the question over here. The state is, the feds, I don't remember. Indian tribes, not subject to this at all. Okay. All right. Decision of the fence viewers has to be by majority vote. This again, according to the statute, has to be by majority vote. And the commissioners, the statute says, can act as a board collectively. Now, this is a procedure issue that's interesting here because the way the county commission does the fence view will determine the appeal rights that a landowner has. Commissioners can act as a board collectively, or any two of them may be appointed, is what the statute says. Now, they act when a landowner asks them to. So either landowner, either of the adjacent landowners can request a view. The commissioners won't do anything on their own. They have to be requested to make a view. So one of the landowners makes a request. And the viewers only have jurisdiction over building and maintenance disputes. That's all they can do. So you build this, you build that, you maintain this, you maintain that. Okay, that's what they're deciding. They're not deciding location of the fence. That's a different issue that they don't have jurisdiction over. So they cannot order an existing fence to be moved, contrary to what some of them think, and then they end up in district court on that, and the court tells them, no, you don't have jurisdiction over that. It's just on building and maintenance. After they come out, make a view, then they'll make a decision. They will assign to each party in writing an equal share, this is what they're supposed to do, an equal share or part of the fence to build, maintain, or repair. Now, equal share is basically in terms of total cost, we're going to split that equally. That doesn't mean same footage necessarily, but it's trying to split the total cost of building that. And that takes into account the changes in the topography and trees and the geography and all of that. Their decision is recorded in the County Register of Deeds office. So that's the next step. If they are acting as fence viewers, okay, so this is where I'm coming back to. Commissioners may act as, do I have a point? Oops, that's not right. Looking for the pointer. Maybe I don't have a laser pointer. That's the pointer? Ah, okay. Okay. So I'm coming back to this issue as to how the commissioners are actually deciding this. Are they acting as a board, or have they selected any two of them to serve as the viewers? So if they're acting as fence viewers, their decision is final, conclusive, non-appealable, binding on the parties and all succeeding occupants of the land. If they don't appoint any two of them, any decision is deemed to be a board decision. If it is a board decision, the normal appeal rules apply. So this is a procedural issue. If you want to appoint two to be as the fence viewers, then you're under that first paragraph, final decision, conclusive, non-appealable, binding on all the parties. If they don't appoint any two of them, then it's a board decision, and then we trigger the normal rules for appealing a decision of the county commissioners. So then a notice of appeal has to be served on the board's clerk within 30 days. Appealing party has to provide a bond, has to pay necessary costs. It's that same procedure. So there's two different ways that a board can deal with these fence views. Pick out two to do it, or do it as a board. So they could all be the fence viewers, or they could select any two of them. Now, then you get the next issue. What if one of the parties doesn't like the decision of the fence viewers and just decides, I'm not going to do anything? You know, they can't make me. One of those. You ever had one of those neighbors? Yeah. Yeah. They can't make me do this. Well, okay. Then the other party can erect, repair, or maintain the entire fence and charge the non-performing party for its share of the cost of the fence plus interest at 1% a month. That's statutory, and fees if legal action is needed to collect that. But don't get ahead of yourself on this. That looks pretty simple. Okay, neighbor says he's not going to do anything. I'm going to go out and do it. And then I'll send him a bill. And then they won't pay the bill. Okay. There's procedure in here that you got to go through before you can do that. And that gets me to Kunze against Schwartz. Northern part of Riley County 20 years ago. And it was about 25 years ago. My wife and I had a place up near Randolph. And I remember it distinctly. It was a Saturday morning. I'm back down a canyon. Can't see the house from the road. It's a stone house. And down the lane comes this truck, knocks on my door. Saturday morning. I'm not expecting anybody. It's Hal Kunze. Okay. Nice guy, really nice guy. He said, I've got a fence problem. And if you're familiar with this area, those two really didn't like each other. And Schwartz had a son that was in my daughter's high school class. So this is all twisted up in small town politics and all of that. It was a mess. I think I must have spent, I don't know, probably 3 or 4 months worth of Saturdays with Hal. And this case ended up all the way through the court system in Kansas. And we got procedure out of this case. Now, this is a big case because this tells you now, and what they had up in North, how many of you know where the place is at, Northern Riley County? You got water through there. And this was the problem. The fence would constantly blow out every time there was water, and he was having trouble. And Schwartz didn't want to fix the fence, according to Hal, and they just could not agree on it. And so they got the fence viewer, the commissioners involved. And of course, I was good friends with one of the commissioners who was one of the former county attorneys, associate county attorney, and also a landowner up there. I mean, this has all types of this soap opera stuff. And boy, it got into the courts and they gave us new procedure. Now this is what you have to do. There's really, the viewers have to make 3 views. 3 views. I didn't anticipate this because this is not in the statute, but the court created this just to get, I think, these parties out of each other's hair. And so we're going to make this fairly complex here. So you make the initial, you call the viewers and they come out and they make the initial view and they make a decision. Okay, one party doesn't comply. And if I remember right, my facts may be, I may have it backwards. I think it was Schwartz that didn't want to comply and Hal had to fix it. Was that the way it was? Those of you who remember? That's the way it was? Okay. So Hal is left to fix it. He said, well, I'm going to go out and fix it. Well, what happened in this situation? The court said, all right, no, you can't just go fix it. You got to call the commissioners out again for a second view because they have to see that the other party didn't do anything. Okay, you call the viewers again to make a second view to determine that the fence, yes, needs to be built or repaired. So there's your second view. Okay, they come out and say, all right, yeah, you didn't do anything. Okay, you can go ahead and fix it. All right, go ahead and fix it. Then you can't just send them a bill. You got to call the commissioners again because they don't have anything else to do. They have to come out and make a third view, verify your work that you did. And the amount claimed that's due is, oh, okay, yeah, that's, your invoice is correct. You go ahead and bill the non-performing party. So there's 3, the initial view, the second view to certify that the other party didn't do anything, and then the third view to certify that the work that you did and the invoice that you're planning on sending is correct. That's the procedure now in Kansas as a result of that Riley County case 2 decades ago. Okay. Now, this is another battle. What do I put up? What can I build? Okay. Do I have to erect the Fort Knox of enclosures? Or what can I put up? This is toward the bottom of page 4 over on page 5. I won't spend a whole lot of time here. I'll just kind of lightly touch on this. I list you can see those bullet points toward the bottom of page 4, the basic types of fences. Following types of fences have to be at least 4 feet high, and post and rails, post and palings, post and planks, palisades, stone, posts and wires, and turf. Okay. The fence statutes are really old. You can have stone fences. I don't know if that stone fence down near, what is it, down near Matfield Green, north of Matfield Green is still there. It was a really nice stone fence that has been there for years. That's a legal fence, or can be a legal fence. On page 5, rail fences or a worm fence. Stone fences have to be at least 18 inches wide at the bottom and 12 inches wide at the top. So there's specific rules for stone fences. Turf fences, hedge fences, post and wire fences. In the judgment of the fence viewer, a brook, river, creek, ditch, equivalent constructions may be deemed to be a legal fence. And then the majority of the fences, though, barbed wire fences. So then I detail out the rules for you on barbed wire fences. Had to basically have at least 3 wires. There are other types of barbed wire fences and other types of fences listed in the statute. I already mentioned the third point there. And the county commissioners can enact more stringent legal fencing requirements on a countywide basis than what state law specifies. So it can even vary from county to county. All right. Now, what if animals get out? What if animals get out? Over on page, and I mentioned electric fences at the top of page 6. What's liability for trespassing animals? Well, if your animals get out of an enclosure that's in good repair, you're generally not liable for any resulting damages. The other party has to prove that you were negligent. So the rule is, no, the livestock owner is generally not liable. Sometimes insurance companies don't understand that, but that's the rule in Kansas. It's favorable to the livestock owner. The other party bears the burden of proof to establish that you were negligent somehow. So they have to have evidence of negligence. You left a gate open. You didn't properly construct or maintain the fence. You knew that you had animals that were in heat and needed a stronger enclosure or put them in a separate pen. You didn't do so. And there are cases on all these. You knew your animals were out and you did nothing to try to get them back in. Okay. That's all evidence of negligence, where you could be held responsible to that motorist that comes down the road and hits the animal on the road and injures themselves or gets killed. Okay. The distraint statute, and I'll come back to the trespassing animal one in just a moment. What if animals get out and cause property damage to somebody else? Now, this is related to fence law, but it's not specifically a fence question. Animals get out and trespass onto your property and cause property damage to you. What can you do? Well, you can retain the animals until payment is made for damages plus costs. If you notify the owner within 24 hours and they don't pick them up within 5 days, you can only hold them for 5 days without bringing legal action. Alternatively, you call the sheriff and have the sheriff come out and get the animals, take them into custody, give notice to the owner, and the owner has 10 days to reclaim the animals and pay costs. If not reclaimed, they're sold at auction. This happened at my place. I've got a small farm north of Topeka, and I'm gone a lot out traveling. And I had been out on the West Coast, and I'd been gone for about 2 weeks. I came home, and I got a steer in my front yard. This is interesting, and I don't think my wife is going to like the divots up by the house. Down by the pond is fine. And he had been watering down by the pond because he left, evidence of being down there by the pond. So he had bathed in the pond and created messes there. And now he's up in the front in the bushes and in the rose beds. So I had a rope out in the barn. I went and got a rope, and he was kind of docile. So I tied him up and asked some of the neighbors down the road, whose is this? And they said, oh, we know whose it is. It always gets out. And, oh, this is the first time it's come over onto you? Yeah, apparently. So I just called the sheriff. Sure, I didn't want to mess with it. I was getting ready to leave again. So I didn't want to mess with it. Called the sheriff, and the sheriff took care of it. And apparently that animal had been out enough that the sheriff decided that he needed to go to auction, is what happened. Okay, so the sheriff has to be, if it's a stray, so we don't know who the owner is if it's a stray. Then we have a different statute. Sheriff has to be notified within 24 hours. And also the party that finds a stray then gets an adjuster's lien for feed and care costs if they follow the particulars of that lien statute. But that's for a stray. Okay. Now, if you move livestock on a public roadway, you can do that, but you have to maintain control. The rule is control. So usually it's good to have somebody in front of them, somebody behind them. If you're moving them from pasture to pasture using a roadway. But if they get out of control, the rule is strict liability. So if you lose control, yes, you will be responsible. Okay. What's that? With today's drivers. Now, railroad fences. And we'll talk about railroad and highway fences, and then we'll be done here. I'm going to skip the question at the bottom of page 7 over on page 8 as to whether fence maintenance statutes are constitutional. There've been a number of cases on that. These crop farmers don't like to pay for partition fences with their livestock owning neighbors. And so they have challenged those fence statutes as unconstitutional in the past. The courts have basically said, nah, they're constitutional. There's a rational reason why the legislatures have set the statutes that way. But railroad fences, how many, anybody here own land adjacent and you got a railroad adjacent to you? Nobody. Okay. If you do, the railroad is responsible. The landowners don't have any responsibility to build or maintain railroad fences. The railroad is responsible for damages caused to livestock. Fault's not an issue. It's a strict liability rule. Doesn't matter whether the livestock got out because of your faulty fence. The railroad is responsible for keeping animals off the track. Now, the railroad can avoid liability by enclosing their tracks with fencing. They rarely do that. And the adjacent landowners can require the railroad to enclose the right of way with a lawful or hog-tight fence. Now, if you've ever tried to make a request of a railroad to do that, you get basically a buzz sound in your ear. They don't. They have to be forced to do that. And they have to be forced to pay. Ultimately, they will, because by statute they have to, but sometimes you have to be forceful with it. Some states do fine railroads for refusing to build fences, and that's in some state statutes. Other states allow the landowner to be reimbursed for cost plus interest for building a fence, and that's basically the Kansas approach. So go ahead and build it, and we'll just build a railroad, and eventually you'll get paid about 9 years down the road. Failure by a railroad to maintain a fence at a public road crossing makes the railroad liable, unless the animals were on the track through the willful act of the owner. But mere negligence is not enough to get you there. On highway fences, the farmer is responsible for maintaining the inner fence. The State Department of Transportation is responsible for maintaining the outer fence. And a lot of times, this is over on page 9, a lot of times we get weed issues on the ground that's in between those two fences. You get noxious weeds that grow up, and then that gets into the noxious weed statute. But that's often a problem in those situations. So what responsibility does the State Department of Transportation have to the motoring public with respect to building and maintaining highway fences? Well, they have to maintain do they have to maintain a cattle tight fence, a legal fence? Do they have to? That's a primary question. Or can they just have, like a one wire fence through there, woven wire fence or a rope or whatever? Must they fence the entire road frontage of a particular parcel? Or what's the purpose? Those questions are basically asking, what is the purpose of a highway fence? Is it to keep animals off the highway, or is it to restrict vehicular access only? So we don't want vehicles entering the highway at any given point. We want to restrict them to a certain entry point. So we have a fence up there just to keep a car from going through this particular area. What's a highway fence for? Well, I'll come back to that point in just a moment, but let's talk about pastures. When we talk about roads and highway fences, this is related to that. In Kansas, you can have fences that can exist by authorization of the county commissioners through pastures. You can gate off a pasture. You can have a road go through a pasture. And then that means you gate it off, or you put a cattle guard on it, or an auto guard. So the county can permit a gate and a fence to be placed across certain public roads. But they cannot authorize the locking of a gate that would bar the general public from accessing the road. So that's why you'll see a cattle guard or an auto gate that goes through somebody's private pasture. Not too much of that in this part of the state. You get a lot of that in the western part of the state, but there is some around here. Now, back on these highway fences. The Kansas Department of Transportation has a common law duty to keep highways in a reasonably safe condition. Now, in a reasonably safe condition would generally mean that we don't have livestock out on the road. Okay, kind of makes sense. So that's what that means in this context. So we're back to the issue of what type of a fence does the highway fence have to be? What is the Department of Transportation's responsibility? Well, we had a case a number of years ago, back in 2001, Reynolds against KDOT. This was Highway 69 going south out of Kansas City down into Miami County. And it's 2 lanes as more of it is 2 lanes each direction separated by median. There's more of that that's been built. It wasn't as extensive 20 years ago, but the first part of it out of Kansas City and down into Miami County was 2 lanes each direction separated by median, big double box culverts that went under the roadway. And what happened was they weren't completely fenced off. Cattle would walk through the culverts, go under the road, come up on the other side. Well, on the other side was an orchard. It was a highway fence that was inadequate to restrain livestock. Livestock then just walk out on the highway, get hit, and one member of the Reynolds family gets killed. So then you got a lawsuit back against the livestock owner, which was a tenant, the landowner, and the Department of Transportation. Now, the landowner is dismissed right away because it's not their problem. The tenant's the one that's responsible in these situations. If there is any responsibility, be the tenant, because it's a tenant's animal. It is responsible for making sure the fence is sufficient to keep the animals in. Okay, so the landowner is dismissed. And KDOT is trying to say, we're out of this case too, because we don't have a responsibility to build a highway fence. We just have a fence up there to keep vehicles from just entering Highway 69 at any point. They can only enter at certain roadways. So that's the purpose of highway fence. We don't have to keep it maintained so that animals are prevented from getting on the highway. So you got a tenant that grazed cattle in the pasture on the west side of the highway. Highway fence constructed by KDOT was built up and around a double box culvert. Tenant fenced the mouth of the culvert. It would wash out. The cattle would escape through the double box culvert to the orchard on the other side. Fence on the east side of the highway was in disrepair. It's a highway fence, as I said. Cow gets out, car strikes it. One of the occupants is killed, somebody else is injured. So several questions. One, does KDOT have a statutory duty to maintain a cattle tight fence? And secondly, was KDOT negligent in not repairing the damaged highway fence? Well, the appellate court said, no, KDOT does not have a duty to maintain cattle tight fences. Highway fences are just to control vehicular access. And then secondly, KDOT was not negligent for not repairing the damaged highway fence. There was no evidence that the cows escaped other than through the unfenced culvert. KDOT has no duty to fence off mouths of culverts. So the trial court judgment for the plaintiffs was reversed, and they got 1.2 million at trial. The appellate court takes that away, but the Kansas Supreme Court reinstated that. And they said, no, the state has a duty to maintain highway fences to keep livestock off the public roadways. Major, major case. Now, we have another one that is still out there right now. This is a live case. This was the trial court decision back in May. There was an accident on I-70 near Goodland. The plaintiff was traveling 80 miles per hour at night, heading, I believe, back east to Indiana. They were from Evansville, Indiana. They'd been out in Denver, going about 80 miles per hour at night. That was the Highway Patrol police report said the cruise was set at 80, some visibility issues, and there was a dead cow that had already been hit laying in the interstate. So it's not a live cow that's out there. It's one that's already been hit that they hadn't removed off the road yet. So he comes through and loses control. It's a Ford F-150, loses control of the pickup, rolls it in the ditch. Now, they weren't killed or anything. They just have a lot of damages. And so then you get the lawsuit. Negligence, comparative fault issues. Who's at fault here? Is it the livestock owner? There was a rodeo barn out near Goodland, and that's near the arena, and the highway fence was near that arena. And that was the question is, does that need to be a fence that is sufficient to keep livestock off of I-70, or is it just basically one rope sufficient? And you get a bunch of motions, and the livestock owner was basically saying there was an unknown trespasser on our property that left some gates open. That's how the animals got out. They was walked right over the supposed highway fence then after they got out of our enclosure. The court basically, they did dismiss KDOT from the suit. They said, okay, this is different than the Reynolds case, because in the Reynolds case, the State Department of Transportation had made an effort to actually put up a highway fence, and they just didn't maintain it. That was not present here. And so there was no duty to maintain what hadn't been put there in the first place. That's kind of short summation of what the court said on that. So KDOT didn't breach its duty. This is now back between the livestock owner as the case proceeds. This was just the trial court on motions. It's now going to go to a jury between the livestock owner and the injured parties, and the injured party has to show the livestock owner was negligent somehow. So we still have another case on this. That's the one that's most recent, decided this just 3 months ago by the federal district court. And the reason that's in federal court is because you have parties from out of state. They came from Colorado, they live in Indiana, so you have federal diversity jurisdiction in this case. Okay. All right. I was hoping to keep it within an hour on the commentary. We came pretty close to that. And there's my contact information, and I'll entertain questions as long as you have questions. Okay, we'll start here.
Okay, question one, your railroad fences? Okay. Responsible for the trees on their side.
Okay, your question is with respect to railroad fences, who's responsible for trees in the corridor? And that would be the railroad. Courts are pretty clear that it's a railroad that has the responsibility to maintain those trees, trim the trees off of there, and build and maintain the fence. Yeah, and that's the second question. How do you get them to do that? Basically, what it comes down to is the railroads say, we don't want to mess with this. You do it and send us a bill. That's how that works.
Another question is, okay, so you have owned this property for years and years, and there's a little, we own 3 sides of it. And Mama died in this little house that she has there. Son moves in, and he decides the fences aren't right. So he has some rinky-dink surveyor do it. And come to find out, after long story short, the fence was out of line, and he refuses to move his fence, and it's pasture fence that has to be put in. So, building those fences, building. But he will not, but he will not fix the other 2 sides of the fence.
Right through his damn building. I got a hole through it, we put it through the building. It was still there.
He wouldn't remove it, so I told him, we'll just cut a hole through it, and we did.
That fence is through the building.
But there's still the other 2 sides, he hasn't done anything to it. And the road goes on the 3rd side.
I'm trying to find a question in all of this. So what is the question?
Who's responsible for all this?
Could have we claimed reverse possession? We've owned the property.
Yeah.
for 50.
Okay. I don't know how I can summarize this for the online audience. Apparently you got a tract, same party owned 3 sides of it. Lady died that lived in the house. Son then takes over the property, hires the Rinky Dink Survey Company, quoting Rinky Dink Survey Company. I'm going to have to use, actually, I'm going to write that down. I'm going to have to use that. That's pretty good. I'm going to use that on an exam at some point in time. The Rinky Dink Survey Company. That's classic. So the survey reveals that the existing fence, I'm still trying to summarize what you're saying. The survey revealed that the existing fence was not on the surveyed line. And it benefited him to not move the fence, so he didn't move the fence. Correct?
Well, he was the one that wanted it done.
Oh, he wanted to move it to the surveyed line.
Yeah.
Okay.
But he wouldn't move his fence then. Our fence was way in, and his went right to the real fence. The survey line went right through his building.
Okay, so a surveyed line went through his building, and of course, he didn't want that, so
He didn't want to put up his fence on the other
he
side.
didn't want to put up his fence on the other side. So you cut right through the building and put the fence in. So now what's the question?
So what really happened? Bought the farm around it. We
Okay.
bought one side, then we bought the other side later.
Yeah.
This tract had been sold off. And they just went from the property, the old property fence, which the road was closed.
And our fence was never moved over to the center of the road.
Okay,
And so,
so you still have fences that are not on the surveyed line.
well, I moved the south fence, my pasture fence over.
Okay,
To the line, but the other side, he doesn't, he was told me he would remove the building.
so you have a fence that is, if I understand this right, partially on the line and partially not on the line.
One side is over to the survey.
Okay,
to the
okay.
New survey.
okay,
And the other side, and he was told me he had a backhoe and all that stuff, and he was going to remove the building. So then he wouldn't remove the building. So I told him, well, if that's the case, I'll just cut the whole other side, cut my fence right through. And I did.
and you did. Okay,
And, but the north property line, he refuses to put that fence in.
Okay, so you've got a dispute with the adjacent owner and you can't figure out how to solve this. This is where probably the procedure would be here. The normal procedure would be to call the county commissioners and have them make a view. Have you done that yet? Call them out. I mean, it's their statutory duty to mess with this kind of stuff. So oh, the commissioners are here? There you go. You just got a job here. All right. Yeah. That's their statutory duty to do that and make them make a decision. And depending on how they want to do it, it's either appealable or it's not. Yeah, that's what you're left with. You can't solve it. That's what the commissioners are for. Okay. Yes.
So if KDOT never builds a fence, are they liable for?
Yeah, this most recent case, his question was, if KDOT doesn't build a highway fence, are they responsible? This most recent case, I thought it was a little weird, and the case is not over yet, but they seem to indicate since KDOT hadn't tried to build a barbed wire fence that we would think of like was in the Reynolds case, they seem to indicate they didn't have to. And what they had a wire rope. And they said that was okay because they'd gone no further than that. I never read Reynolds that way, but the federal district court seemed to read the Reynolds case that way and said, we're distinguishing Reynolds because of that. But again, the case isn't over yet. That was just on motions. We'll have to see what happens on that one.
For instance, two properties are cropped.
Mhm.
So one decides he wants to raise his side.
Okay, yeah, I get this question all the time too. So this goes back to that in common usage part of the Kansas statute. We got crop farmer, and now one party wants to put stock in. And if you have crops and one party wants to put a fence in, and they're not going to livestock, but it's crops and crops, then the other party doesn't have to because it's still common usage. But once they put livestock in, it's no longer used in common. That exception no longer applies, and now both parties bear an equal share of the cost. And that tricks a lot of people because that now it's no longer common. And that means both parties are now responsible. Yeah, good question. I missed that. I forgot to say that in the initial discussion. Yes, ma'am.
So if you live on a west highway and you don't have a KDOT fence there, and somebody flies off the highway and comes through the fence and your animals get out and cause damage, like, that's not negligence on your part, or is it?
Yeah, that's a good question. I'm going to give you a case on this because I teach this case to the law students, exactly what you're mentioning there. I'll pay you off afterwards here for bringing that up. Her comment was, there's no highway fence. We own land adjacent to a state road or state highway, public road. It could be anything like that. But there's no highway fence and it's just our fence. Car goes off the road, goes through our fence. Maybe our animals get out. I'm just throwing that in there. Am I responsible for that? There's a case out of Indiana a few years ago. Now I'm from Indiana, and if you've driven in Indiana, you know the roads are narrow and they're hilly. They don't grade anything, and everybody farms right up to the edge of the road. There's no shoulder. And I remember 30 years ago when I first moved out to Iowa. Wow, what's this stuff on shoulders on the roads? Cool. Yeah. I've been risking my life riding a bike and running on these county roads and getting hit. Wow, they actually have space. But no, you farm right up. You got a concrete culvert right there, which wipes out cars, and it's a good way to rack farm equipment too. But there was a case out of Indiana, and this guy was on a county road on a curve. His horse pasture was on a curve. It was an S curve. It kind of came up around his pasture like this. And cars would fail to negotiate the curve routinely and go right through his fence, and his horses would get out. And then he's got other problems. And so he would talk to the county, and the county wouldn't do anything. He talked to the state. State wouldn't do anything. State wouldn't force the county to do anything, and vice versa. So he got tired of it. And so he went out and he put up a barrier outside of his fence, but between his fence and the road. Can he put a barrier in the ditch, kind of like a guardrail is what he did. Well, a motorcyclist comes down and fails to negotiate the curve, hits his guardrail and injures himself. Well, it protected his fence. And so this guy gets sued for intentionally putting this up to intentionally harm a motorist that goes off the roadway. The court said, no, that's not an intentional tort. He didn't put the fence up to hurt a motorist. He put a fence up, or put a barrier up, a guardrail up, to protect his fence. So I think that's kind of what you're getting at here. If somebody goes off and goes through my fence, no, you're not responsible for that. Can you put a barrier up in the right of way, in the ditch, to protect your fence? Technically, yeah. You might get sued, but the Indiana court said there was no liability in that situation because your intent was to protect your fence, not to hurt a motorist. Okay. Yeah, or to follow up on that, what if somebody does fail to negotiate a curve, goes through your fence, your animals get out, another car comes down the road, hits your animal, and somebody's injured, and they sue you, are you responsible? Not in Kansas, because the rule is they have to show that you were negligent. It wasn't your negligent that led to your animals getting out.
So they got this deal on hit and run, accident.
Hit and run accidents?
You're always supposed to report it if you hit. Well, I have brand new fence
Mhm.
on Erickson Road.
Mhm.
Somebody came around and didn't make the curve, and went through my fence.
So you had a car go through the fence and they took off.
And they took off. Well, I called the sheriff out there.
Yep.
And I said, well, can't you get him for hit and run? Should he wreck my fence? Well, he didn't seem any concerned of anything at all about finding him for hit and run on my fence, but anything else they do.
Okay, so what he's saying was he's got land alongside a road. Motorists went through the fence and called the sheriff, and the sheriff didn't seem interested in figuring out who did this, nor to try to find out who did it. But his comment was anything else that would be treated as a hit and run. Yeah, I don't know what to tell you about that.
Well, it looks to me like if you hit the fence and run, it ought to be the same.
Well, yeah,
If I hit something else, if I hit the guardrail and tore it up with my machine and took off and then
Yeah.
said nothing, why?
Clearly, the ethical thing to do would be, if you go through somebody's fence, to self-report on that. But if the county doesn't want to go after, I don't know what you do in that situation. That reminds me of something on our farm back in Indiana. The neighbor down a mile down the road, right after the county, for the first time in 25 years, decided to actually kind of resurface the road. Instead of doing one of these things where they take the county truck out and kind of just dump some stuff and then don't even get out of the truck. They just run the tires over it to do it that way. That's the way they do it, literally. Just dump some stuff out, back over. So now they made an effort to actually repair the road. The very next day, neighbor down the road has he's out doing field work, and he pulls out of the field onto the new roadbed that's not really set yet, and he forgot to raise his disc. Quarter mile before he looked back, oh no. So he calls the county, and county came out and fixed it, and he paid for that. But that's the right thing to do. In this situation, I don't know what you can do if somebody's not going to self-report what they did. Back here.
So you said that if you have control of your animals, you can take them across the roadway,
Right. If you make the rule for moving animals on a public road is that you have to maintain control. Now, control is a sometimes thing.
So I have a situation where unbeknownst of us, the gate got left open and a couple animals got out. And as we were taking them across the road to put them back in, the car hit one and killed it. And the insurance found us liable because we left the gate open. But he had control of them, taking them back across the road.
Okay, so you had animals that got out because you left the gate open?
We did, but yes, they got
Be-
through a gate.
Because you had a gate that was left open. Okay, so then they go across the road onto a neighbor, the neighbor,
No, it was our ground on both sides of the road.
okay, so you have the ground on both sides of the road.
And we were taking the animals back across the highway, put them back into the pen they came out of.
Okay,
And a car,
okay, so your animals get out of the pen over here, they cross the road, you go get them, and as you're bringing them back, a car hits them. Okay, and insurance company refused to pay because they said it was your responsibility?
they said it was our responsibility. I think they ended up taking care of it, but I'm sure our insurance rates went up.
Yeah. Well, the issue on that one is what, did you have control of them as you were moving them back? Were there sufficient warnings put up to motorists? You know, was there a hill where somebody popped over a hill and couldn't see what was happening?
On top of the hill, they could see both ways.
Okay,
They were on their phone.
those are going to be the factors. I mean, what's the visibility? You said somebody was on their phone, they just looked up too late and hit them. Again, it's one of those fact patterns where it's going to depend. You know, if you pop up over a hill, that's where you need somebody at the top saying, wait a minute, we're moving some cattle across here, or horses or whatever. But you don't necessarily have that same responsibility if it's not a hill. So it just depends on the situation. Couple more right here.
You do that same thing with machinery.
The same rule would apply with respect to machinery.
We can stop people at the end of the combine.
Yes, yeah. You want to have people probably behind with flashers on, maybe out in front as you're moving machinery down a roadway too.
Even on a state highway or federal highway.
Federal highway, no. Stay off of interstates. In fact, interstates will prevent you from doing that. Yeah. State highway is a little different, yes, but you want to make sure that you have people in front as you're going from field to field. Now, this is a situation where you're not going 15 miles from one place to another. This is just going from one field to another.
Can you actually stop the traffic
Can you stop the traffic to cross?
so that you can get from one field entrance, say a quarter or a half mile down?
On that one, I would suggest that you call the county sheriff and have the sheriff help you move it in that situation. And most of the time they'll be glad to come out and put a deputy out there while you need to move across.
I don't know if this pertains. What, you drive around, you see fence posts painted purple, what's that mean?
That means you can hunt there. It's the purple paint law.
You can, without permission.
If I remember the statute right, I haven't looked at that for a while. That came in about, what, 20 years ago? It's the opposite. Okay. Yeah, it's the opposite. I knew it was one way or the other. Oh, wait a minute. Wow. I guess I can't hunt there. So it's the opposite. All right. Well, I had a 50% chance. Yeah. I had related to that, I had somebody call me a few years ago. They had a trespasser on their farm and wondered what they could do. And this was a call I got one day in my office at the law school when I was actually there one day. And they said, I had a trespasser. What is the proper way to make sure, what can I do to prevent this? Because I'm having people do this all the time. And, you mentioned the purple, and this is what reminds me of this. And I talked to him for a while, and I said, well, do you know who it is? Can you identify them? oh, I think I know who it is. And they were wearing, looked like a KU hoodie on this last time. That's what he said. So then, I'm a little bit ornery. And I said, well, if you want to keep them off your property, just spray paint your field green, paint white lines on it and make an end zone. They'll never find your property. I thought that was pretty good for spur of the moment. He said, that's a good idea. Yeah, actually. Okay. All right. Anything else? Here and then the back, and then we'll probably cut it off.
Do you have to have no trespassing signs up to get someone that's crossing your property?
Okay, something related to fence law. How good is a no trespassing sign? What do I have to have a no trespassing sign up to keep people off my property? What posting your property does is convert a civil trespass to potential criminal matter. Potential, I say potential. But that's basically what posting your property does, is allows the state to get involved in prosecuting the trespass. If it's not posted, then it's just a civil trespass.
Well, I had these people, they in my phone.
Yeah.
I got tired of it, but they never asked, they just do it.
Mm-hmm.
So I called the sheriff out, and he wouldn't do nothing because I
'Cause-
didn't have a no trespassing sign.
Because you didn't have it posted. That's what I was saying. His comment was that he had problems with trespassers coming on fishing, called the sheriff. The sheriff wouldn't do anything because he didn't have the property posted. That's what I mean. It's just a civil matter. If you don't have it posted, the county's not going to get involved. If you post it, that can convert it into a potential criminal matter that then gives the county jurisdiction to deal with it.
I'm gonna tag that real quick and ask, how many signs are you gonna have to have up that say no trespassing?
Yeah. How many signs do I have to have up? It depends. It also depends on the location where they're at and the type of land that you have. There may be places where there's no way people can enter your property because the brush is too thick. So you don't need a sign there. You need a sign where people are likely to come in. Not my place is like that. I've been clearing brush for 5 years. Just finally broke through to the north fence line. I mean, it's so thick, you can't hunt it. You can't walk through it. Daniel Boone himself would have never been able to get through there. You don't need to post that. But if there are areas where people can come in at, put signs there. So there's no set number of signs. One more question back here and then we will have to stop because it's past Chuck's bedtime. He's got to get to bed.
Illegal fence
Mhm.
in all positions, even.
Okay, is an electric fence a legal fence in all positions, even next to a highway? We do have state statute on that. I do talk about that in the material. There are different types of electric fences, the types of charges and the locations where they can be. And that's all in the statute. Yeah. Again, it depends. Okay. Anything online, Robin, before we dismiss? Or
You'd be here all night.
it was like 400 people
I'll
online.
be getting some emails
Oh, great.
later tonight, tomorrow.
Great. Good. Well, thank you very much. I appreciate it. And Chuck, I'll turn it back over to you.